Senior citizen matter means?
No, no, my lord. Both are, my lord, above 60 years age. My lord, petitioner is the, my lord, father and mother. Son was on employment,
this is
died,
that
daughter is
matter.
got an employment. Not maintaining or not giving financial any assistance, so they came before this court.
I indicate two, three things before your question. First of all, the widow, daughter-in-law, and his minor child is 7-year-old.
No, I want that Mr. Bishwabhatam, inform Mr. Bosu Mollik to be present in the second half at 2 p.m. At 2 p.m. আমি ঘুরে আসছি, ওটা হবে না, মিটিং আসছি। Because you have to resolve the issue. Otherwise, what will happen?
I have to show your lordship.
You are asking, you are paying for family pension, na?
Yes.
No objection, no objection, they will not giving.
Yes, my lord, I am indicate some. Kindly, your lordship, peruse on my affidavit in opposition.
What do you want to say?
Thing is that we have went to the mediation. We have asked them to. I will give rupees 5,000 to the parent-in-law. Okay. Then after, we have also asked them to not to transfer the property.
Don't enlarge the issue. Mr.
Property.
Bosu Mollik, unless the demand of the parents-in-law is 10,000 rupees.
Yes, my lord.
The wife is not, widow is
He
not.
says she admits clearly that except 5,000, I will not pay anything.
Achha. Is there any problem with regard to the property? She wanted to raise?
Because
Yes,
so
my
with
lord.
regard to these properties, parties concerned, I am. That is not my lookout. His lordship has directed to.
Mr. Bosu Mollik,
Madam.
as a mediator, you have been asked to mediate the entire situation.
Lordship.
You can enlarge the scope. If it is found that the daughter-in-law is saying that I have a right to reside in my husband's property, they are not allowing. So this will also come within that purview, that if they will allow the daughter-in-law to stay. And if there are any other issues, it's a permanent solution, not the piecemeal solution.
No, my lord.
What is your proposal?
No, for that, my lord, I do not know whether the record has come from the mediation center or not, because I have taken a written notes from written agreement from both the parties with regard to their claim and counter claim. They have handed up, and everything is with that record, my lord. I think, my lord, that whether that record has come or not, I do not know, my lord.
Kindly peruse our submission.
Both the my lord, both the parties has filed their written version before me. Thereafter also, my lord, I couldn't unable to.
What was your prayer?
My prayer is that.
Have you written it down? Written it down?
My lord, I have submitted before the
Mediator.
Yes.
I will call for the record if necessary.
The petitioner forcefully driven out the opponent number
This
6
is
from the house. Yes,
This
my
is
lord.
not a case.
For this, my lord, there is a they say something, she says something.
Title suit filed by the, my lord, daughter-in-law before the, my lord,
Yes, my
civil
lord.
judge junior
Wait.
petition that was pending.
Prior that phone.
Wait, please.
Yes.
Has to provide 2/3 share. You have made the situation complicated. You have made the forget about 5,000. Your terms is criminal case filed by the respective parties will be withdrawn. Secondly, suit you have filed, you'll be withdrawing subject to the condition that your 2/3 share on the husband's property and 1/3 share they may enjoy, but it should not be given to the married daughter. Instead, they should make the gift in favor of the granddaughter.
Yes, my lord.
Right?
Yes.
But one complication your client has already made by gifting the share to the married daughter.
Well,
If you-
when, my lord, transfer situation is that when the, my lord, parents was
100%.
driven out by the
No, I
daughter-in-law and
understand.
its associate.
Very well. Today,
That situation, my lord,
today you are ready with the arrangement. Supposing you are getting 10,000, supposing you will be allowed to enjoy 1/3 of your son's property so long you are alive. and thereafter you will make arrangement for transfer of it in favor of the granddaughter instead of who will allow if husband's property you want to give it to the married daughter, certainly the widow will not allow to the detriment of your this is not your granddaughter.
And I have already disposed from the property. For that, I have
No,
filed
that
the-
the
There
court
is
will
no
put you in
dispute.
possession. But you really want to resolve the issue. What is the situation? Whether you can stay there separately, you will stay over there. But if you have already you have given to the married daughter, there is a permanent problem you have injected in this family. Let the grandchildren get it.
When Milo driving out
Your
by the
client,
van,
your
that
client,
Milo daughter is
your
given
client,
shelter.
make your client.
Daughter is given shelter so that Milo says that
No,
time
no,
Milo-
come to your own house.
at present Milo come back.
Then both of you separately live separately.
Yes.
Now come to this problem. The daughter may have given you the shelter, but the property of the father means the daughter, granddaughter, she is only entitled to the property of her father. How you can give it on the strength of your succession to a married sister, a married daughter of the parents-in-law? Make your clients sensible because they are also aging. They want to fight in court or they want to settle the issue. Three things are there. She has to pay 10,000 per month. All the cases between the parties will be withdrawn. Thirdly, the gift deed you have to cancel or otherwise you have to give it to not to your daughter-in-law but to your granddaughter. And you will enjoy it your whole life. And with the undertaking, yes, after my death, the granddaughter will be getting after the date of the grandparents.
Now Milo this petitioner is not a owner. Milo they have registered in their daughter. Milo, if the Milo daughter is not agreed,
Now the
how will
daughter,
be
no,
difficulty, Milo?
make the daughters. You have gifted it. You have gifted it. Gifted it. There is ways you know as a lawyer how to cancel it if they are not agreeable.
Yes,
Make them in sense. Then don't take this everything. Let this be family pension. You will not get the family pension, and you will also not get anything.
No, Milo. Milo similar situation, Milo
Family
division
pension
bench
amount is
of this
my lord,
High
I am not going by any order of this court.
Family-
This is a mediation.
Property dispute, Milo, whatever the portion they are getting, Milo, 1/3 Milo is
I will not keep anything alive. You have no liability. If
No,
you
Milo.
not allowed to.
They have
you
driven
have
out,
prayed
they-
for
they have
what?
not
What
given
you have
money,
prayed for?
so
What is
Milo,
the
daughter
prayer?
gives
Prayer is Milord
to
to
enter
get
the
the
property, so Milo,
money
register
so
the
that
name of the daughter.
her livelihood,
Register the
their
property in the
livelihood
daughter.
can be Milord.
No. What is your prayer in the writ petition?
I think livelihood.
Not a property dispute here.
She is getting money, but she is not look after
Oh.
us.
Oh,
This is the
not
only-
the-
One
This is
notification also not
this is not the forum.
The petitioner is
You are
not
getting
giving
family pension. You are getting family pension,
Yes.
8,000 something amount.
And you
Total
are
she get
also-
39,000.
No, my
and
lord.
you are in died in harness.
The salary is.
Answer me, na. You have got a job.
Yes, yes.
You are getting family pension.
Yes, I am.
You are living separately
With
The
her
thing
with
is
her
that,
daughter.
Yes,
with a daughter.
to a rented house. Due
Sorry,
to that,
this prayer cannot be entertained. আমি দুটোর সময় এসে করছি এটা
Property issues not dispute before